some details in this story have been changed, but the emotional truth remains.
3 weeks before the hearing, I received a courier envelope thick, formel, addressed to my full legal name, Thomas Caldwell. I opened it in my car, parked in the driveway. The words sat centered at the top of the first page: emergency petition for temporary financial conservatorship. Lydia wasn't seeking guardianship over my mother. She was seeking it over me. In the petition, she claimed I was unable to recognize financial exploitation, incapable of responsibly managing personal assets, and functionally impaired in judgment due to prolonged disengagement from household financial decision-making. The word incompetent did not appear, but it hovered there. Within 48 hours of the filing, my bank notified me that my personal accounts were temporarily frozen pending review. No conclusion, no accusation, just standard precautionary procedure. The next morning, I received an email from Human Resources. Subject: temporary administrative leave. The message was brief, neutral, procedural. My company operates in risk governance and internal audit. Allegations regarding financial incapacity, even personal ones, are not something the firm can ignore. Given the allegations currently under legal review, the email read, the company believes it is in the best interest of all parties to place Mr. Ham Caldwell on temporary administrative leave until further clarification. There was no use of the word disciplinary, but there was no use of the word support either. 2 days later, an internal message was mistakenly routed to me before my system access was fully restricted. I was able to read only a portion before it disappeared. Given the allegations and the nature of Mr. Caldwell's role in compliance oversight, it may be prudent to remove him from Project Northbridge pending review. Project Northbridge was the largest internal investigation the firm had launched that year. I had led it for 6 months. By that afternoon, my name was removed from the assignment roster. No one called to explain. HR scheduled what they described as a capacity review session with an independent psychological consultant, framed as a routine procedural safeguard. I understood the process. I had helped design processes like that. When risk indicators appear, systems protect themselves first. The problem was that this time, I was the flag variable. That evening, I opened my personal email and found a message from Ryan. He didn't call. He wrote, Dad, Mom says this is about protecting you. She says you've always stayed out of financial decisions. I don't know what's true, but if the court needs statements, I'm willing to confirm that Mom handled everything. There was no accusation in his message, just uncertainty and distance. I read it more than once, not because I didn't understand it, but because I was trying to identify the exact moment when the story about me had been finalized in someone else's mind. I didn't respond immediately, just like in the courtroom. A rushed reaction would only reinforce the narrative already constructed. But this time, the stakes extended beyond family. They reached into 20 years of professional credibility. In my field, reputation is not lost because you lose a case. It is lost when doubt emerges about your ability to manage your own financial life. A man considered personally incompetent cannot be entrusted to detect misconduct in others. I didn't feel anger. I felt the system functioning precisely as it was designed to function, except this time, it was functioning against me. And I knew that without clear evidence, airtight logic, and absolute patience, I wouldn't just lose a hearing. I would lose the right to be trusted, permanently. Lydia didn't take control of our family's finances in a single day. She did it gradually. At first, it looked like initiative. After Ryan left for college and Hannah began preparing her applications, Lydia suggested moving our savings to a more flexible bank. I didn't object. The transfer was completed one afternoon while I was still at the office. I signed already. She told me that evening. It was faster. You were busy. It didn't feel like a major decision, just a signature that didn't include me. Then came the life insurance policies. Lydia added herself as the primary contact because, as she put it, they respond faster if they're dealing with one person. After that, the investment accounts, then the recurring payments. Each time, there was a reasonable explanation. Each time. I told myself that trust in a marriage didn't require auditing every detail. I don't know exactly when my role shifted from co-decision maker to informed after the fact. But I remember one dinner clearly. Ryan was about 17, asking about student loans. Hannah sat beside him, listening more than participating. I began explaining interest structures, the difference between federal and private loans, the long-term implications of variable rates. Lydia interrupted. Ask me, she told the kids lightly. Dad doesn't really deal with money. She said it with a faint smile, as if it were a joke. No one laughed. Ryan turned toward her. Hannah did too. I didn't correct it. At the time, I told myself she was simplifying things. I thought staying quiet was maturity. Arguing in front of our children about financial control felt selfish. I was wrong. Silence, repeated often enough, stops being restraint. It becomes documentation. About 2 years before everything unraveled, I asked to review our joint investment statements. Not out of suspicion, I had received a tax notice that didn't align with our projected allocations. I'd like to see last month's statement, I said one evening while Lydia stood at the kitchen counter. She didn't look up immediately. For what? I just want to double-check an allocation. She set the knife down and turned toward me. Not angry, just assessing. You don't understand these things. Thomas. It wasn't loud. It wasn't hostile, but it carried weight. I work in financial risk management. I replied calmly. At your firm. Maybe, she said. But this is family. It's different. She didn't give me the statement that night. She said she would send it later. I never received it. I didn't ask again. At the time, I convinced myself that marriage wasn't an audit, that tracking every transaction could damage trust, that allowing one partner to lead in certain areas wasn't a failure. What I didn't see was that while I was trying to preserve peace, Lydia was building a narrative in which she was the only one who understood the numbers, a narrative in which I didn't like dealing with finances, a narrative in which my absence was noted, repeated, and gradually reframed as evidence. When the conservatorship petition was filed, the language in it didn't come from nowhere. It had been constructed over years, from dinners where I chose not to correct her, from signatures completed without me, from moments when I opted for quiet rather than clarification. Lydia didn't need to fabricate an entirely new reality. She only needed to repeat a carefully edited version of the truth often enough. And I helped her do it by believing that silence was a mark of maturity. I didn't understand that sometimes silence is simply the space where someone else writes your story for you. My mother, June Caldwell, suffered a mild stroke late last winter. It wasn't severe enough to take away her speech, not serious enough for the doctors to use the word cognitive decline, but it was enough to slow things down. Her short-term memory occasionally slipped mid-sentence. Some afternoons she couldn't remember whether she had taken her medication. It wasn't dangerous, just more fragile than before. June had always been careful with money. After my father died, she kept the habit of balancing her checkbook every Sunday morning. 2 sugars in her coffee, a small notebook open beside her. She once told me, "Paper is memory. Thomas, don't lose it." When she was discharged from the hospital, Lydia offered to help. "You need to focus on caregiving," she said. "Let me handle the paperwork." The bank. The insurance? It sounded reasonable. I was juggling hospital visits, work responsibilities, and the quiet effort of making sure my mother never felt like she was becoming a burden. Lydia stepped in like an anchor. She scheduled follow-up appointments. She called the bank to notify them of June's medical situation. She reorganized insurance files. One afternoon, while I was in my office at home, I overheard Lydia answering a call in the living room. "Yes, I'm her daughter-in-law," she said. "Thomas is busy. I can respond on her behalf." I didn't ask who it was. Months later, I remembered that call. Only once. When I was scrolling through my mother's old landline call log, I noticed a small handwritten note beside an unfamiliar number. Compliance, follow up. At the time, I didn't think much of it. After the stroke, Lydia began bringing documents to my mother's house more frequently, just simplifying things. She would say, "If anything happens, everything will be clear." One afternoon, I saw my mother signing a thick packet of papers. Her signature trembled slightly, but it was still hers. "What is that?" I asked. "Power of attorney," Lydia answered before my mother could. "Just as a precaution, in case she needs someone to work with the bank on her behalf." My mother nodded. "Temporary," she said. "Just for convenience." I didn't object. In my field, a POA isn't unusual. It's a legal instrument, neither good nor bad. Its meaning depends entirely on how it's used. But I didn't review the language carefully at the time. I assumed good faith. Over the following months, Lydia became the primary point of contact for financial institutions regarding my mother. Mail began arriving at our house instead of June's. Calls were answered by Lydia. Questions were handled. June never complained. But she also grew quieter when money was mentioned. 3 months later, she passed away. The funeral was simple. White flowers, close family, stories about a woman who never missed an electric bill. 3 weeks after the funeral, I received the petition. Emergency conservatorship. Not for my mother. For me. I sat in my car for a long time after reading it. I thought about the POA, the slightly unsteady signature, my mother's words, "Paper is memory." I began asking questions not from suspicion, but from logic. Why did my mother's financial authority need to be simplified before anyone had requested it? And why? Only weeks after she died. Did the narrative about financial incapacity shift toward me? At that moment, I didn't have answers. But I began to understand that documents signed during moments of vulnerability are never just paperwork. They are starting points. And I had not examined them closely enough at the one moment when it mattered most. "He's just a useless husband." Lydia said it in open court without raising her voice, without trembling, without bitterness. Her tone was so even, it sounded rehearsed like a conclusion written years ago and finally read aloud. No one in the room reacted immediately. Courtroom 3B in DuPage County didn't look the way people imagine courtrooms do. There were no packed galleries, no whispers, just a few worn wooden benches, cold fluorescent lighting, and the faint mix of old paper and disinfectant that clings to government buildings, no matter how often they're clean. I sat at the table to the right, shoulders straight, both palms resting flat against the wood. Years ago, I learned something simple. A clenched fist is a statement. Open hands are not. Anyone familiar with a courtroom knows even the smallest gesture can be interpreted. I had no intention of offering anyone extra material to read. Lydia didn't look at me when she said it. She stood a few feet away, angled toward the judge. Navy blazer, neutral makeup, the pearl necklace she wore whenever she wanted to appear calm and credible. I had lived with that version of her for 26 years. I knew exactly how many times she had practiced that voice. Her attorney had just finished outlining the narrative, a wife who carried the financial and emotional burdens of the household for years. A husband passive, withdrawn, incapable of long-term planning. Words like concern, stability, and protection repeated with careful precision. Then Lydia added her closing line. "He doesn't understand finances. He never has." I didn't react. Not because it didn't hurt, but because reacting would complete the story she was building. Lydia had always believed silence meant emptiness. She mistook restraint for absence. That misunderstanding was the foundation of everything that followed. Judge Marlene Sykes didn't interrupt right away. She leaned back slightly, removed her glasses, then put them on again as if adjusting her focus. Silver hair neatly cut, the calm eyes of someone who had heard thousands of cases and learned to recognize where narratives didn't quite align. She didn't look at me. She looked at Lydia's attorney. "Counselor," she said evenly, though there was an edge beneath it. "Are you certain you understand who Mr. Plain Caldwell is, and what he actually does? There was a pause. Brief but long enough for the entire room to feel it. Lydia's attorney blinked. Yes. Your Honor, he works in operations, risk management. I believe. The judge tilted her head just slightly. And you're confident that's the full picture? I saw Lydia stiffen for the first time. It was subtle, a tightening of her jaw. Not fear. Not yet. But something had shifted off the trajectory she expected. I hadn't planned for that moment to arrive so early. I assumed I would sit quietly for another hour before anything changed. But Judge Sykes had a habit I had observed in other proceedings years before. When a story felt too polished, she asked questions sooner than expected. She tapped her pen lightly against the bench. Mr. Mark Caldwell, she said, turning to me for the first time. You've remained silent so far. Is that intentional? Yes. Your Honor? Why? I held her gaze. Because this petition depends on assumptions, I said slowly. And assumptions tend to collapse when facts are introduced too early. No one spoke for several seconds. Lydia inhaled, barely audible. The clock above the judge's bench read 9:14 a.m. It was the first moment that morning when Lydia Caldwell's certainty developed a visible fracture. And I knew, even if no one else yet understood it, that the story was no longer entirely in her control. The morning after, I slept on the couch. I opened my laptop. Not to argue. Not to call anyone. Just to look at the data. In my field, emotion is never the starting point. Data is the first thing that speaks. I logged into every account I still had access to and downloaded 12 months of my mother's bank statements. Then I accessed the joint accounts Lydia had authority over through the power of attorney. I wasn't searching for anything specific. I was searching for patterns. I built a timeline. Dates in the left column. Transaction types on the right. Notes in the center. At first, everything looked ordinary. Utilities. Pharmacy charges. The same grocery store June had used for years. Her financial rhythm had been steady, predictable, nearly unchanged for over a decade. Then I began noticing small transfers. Not large, not enough to immediately alarm anyone. Yuan, Babai, Yuan, Lambai Wush, Yuan, Ibai, each labeled as consulting support or administrative facilitation. There were no attached invoices in the statement history. No detailed service descriptions. I pulled more data. When I aligned those transactions with Lydia's visit, scheduled the days she said she would stop by to organize paperwork, the dates matched almost perfectly. Not every time, but enough to eliminate coincidence. Another detail stood out. Every transfer fell just under the bank's mandatory reporting threshold, below the trigger point for enhanced automated review. That didn't prove intent, but it suggested familiarity with how systems flag activity. I kept going. In my mother's forwarded email archive, I found a PDF Lydia had sent her, an invoice from a name I didn't recognize, Pierce Administrative Services. The amount matched one of the transfers. I opened the file. It looked professional. Minimalist logo, reference number, vague service description, financial documentation assistance. I didn't question the wording at first. I checked the file properties. In my profession, metadata is not decoration. It's trace evidence. The file creation date was clear. 11 days after the transfer had already occurred. I stared at it. Maybe it was a reissued copy. Maybe the file had been modified. I opened 2 additional invoices. One created 9 days after payment. Another 13 days after. Not a single anomaly, but no longer coincidence. I didn't call Lydia. I didn't call a lawyer immediately either. I saved the files into a separate folder and named it simply Sequence. Then I continued building the timeline. Each transfer highlighted in color. Each visit logged. Each invoice cross-referenced. By late afternoon, I didn't have proof of a crime, but I had structure. A structure in which the money moved first. The invoice appeared later. The amount stayed below reporting thresholds. And I knew something critical. In any investigation, the most important move is not what you discover first. It's what you choose not to reveal too early. When I called Dana Mercer that evening, I presented the timeline, the consulting fees, and their correlation with Lydia's visits. I did not mention the metadata. Not yet. Do you think this is error or intent? Dana asked. I think it's a system, I replied. I could hear her writing on the other end of the line. Then we'll let another system examine it, she said. After the call, I closed my laptop. In the living room, Lydia was watching the news as if nothing had shifted. She believed I wasn't paying attention. She believed I didn't understand. She believed my silence confirmed the story she had built. What she didn't know was that I had begun reading between the lines, and there was one small detail, just a timestamp, that I was keeping to myself. It wasn't time for it to surface. But when the moment came, it wouldn't need to shout. It would simply need to be accurate. I didn't return to my mother's house immediately after receiving the petition. Part of me, I think, wasn't ready to look at anything that might confirm what I was beginning to suspect. But 4 days later, on a gray March morning, I drove to Oak Park. The house was still there, quiet, as if nothing had changed. The low fence, the lawn trimmed before winter, the porch light still set on its automatic timer. Everything looked like a life paused, not finished. I unlocked the door with the old key. The scent of lavender and aging paper lingered in the air. The living room was orderly. A folded blanket draped over the arm of the couch. Reading glasses placed face down on the table, exactly where my mother always left them. I went straight to the spare bedroom where she kept her beige 4-drawer filing cabinet. June never believed in keeping things in your head. She believed in paper. I opened the first drawer. Utility bills, property tax statements, sorted by month. As always. The second drawer, banking. At first glance, everything appeared normal. But when I pulled out one envelope, I noticed the adhesive edge had been opened and resealed. Not torn, just slightly misaligned. The glue folded back on itself. I pulled out a few more. 2 of them showed the same subtle signs. June never opened mail and resealed it. She filed envelopes exactly as they arrived. Even after reading them, I began laying the statements out chronologically on the bed. January, February, March, then a gap, not entirely missing, but 2 consecutive months absent from the sequence the previous year. In their place was a thin, unlabeled folder clipped together with a metal fastener. Inside were printed transaction summaries, not official bank statements. The header font didn't match the others. Someone had recreated the data. I moved to the legal drawer. The power of attorney was there, not hidden. My mother's signature was slightly uneven, the ink heavier in places. The execution date matched a neurologist's note in her medical file. Increased confusion, fluctuating executive function. Not incompetence, but heightened vulnerability. I set the POA aside and kept searching. The journal was in the hallway closet, tucked between 2 old photo albums. Brown leather cover, edges softened with age. I didn't remember her ever mentioning it. The first entry was dated over a year earlier. At first, the tone was ordinary. Notes about the weather, doctor appointments, Lydia stopping by with chicken soup. Then it shifted. Foggy today. Lydia had papers, said they were to help her talk to the bank. I signed. Shouldn't have. Too tired to argue. I stopped reading for a moment. 2 weeks later, better day. Looked at papers again. Power of attorney. Didn't mean to give that. Embarrassed. Don't want to trouble Thomas. My chest tightened, not with anger, but with clarity. I turned to the final entry. The handwriting was slanted, less steady than earlier pages. If you're reading this, something has gone wrong. I didn't forget who you are. I know what you do. I trusted you to see what I couldn't. I sat down on the closet floor, my back against the wooden frame. I didn't cry. I just breathed. I returned once more to the filing cabinet. In the back corner of the bank drawer, I found a small folded piece of paper, not inside an envelope. The handwriting wasn't my mother's. The strokes were darker, faster, Call me before signing anything else. No name. Just a phone number that had been crossed out. I took a photograph. I didn't know who wrote it, but I knew it wasn't June. Before leaving, I placed everything back exactly as I had found it. Originals, untouched. I took only copies and images. The strongest evidence is evidence that has not been disturbed. When I locked the door and stepped back onto the porch, I looked at the house one last time. Lydia believed I hadn't noticed. But my mother had left more than a journal. She had left gaps. And in my line of work, gaps are rarely accidental. Ryan didn't call first. He showed up at my door on a Saturday afternoon. Shoulders tense. Eyes no longer searching for explanation, but carrying the weight of someone who felt forced to choose a side. Mom says you're using your job against her. I opened the door wide enough for him to step inside. But he didn't sit down. She said that? I asked. She says you're weaponizing your job, that you're manipulating the system because you know how it works. I looked at him longer than usual. What do you think? Ryan shook his head. I think if you didn't have that job, this wouldn't have gone this far. I understood what he meant. It wasn't an accusation. Just the simple logic of an outsider. If I didn't work in compliance, if I didn't know how to read data, if I didn't understand how banks respond, Lydia wouldn't be under scrutiny. Do you think I fabricated the statements? I asked. Ryan didn't answer. That silence was more dangerous than an accusation. Hannah called me later that night. Her voice trembled. Mom wants me to sign a statement. What kind of statement? Something confirming that she's always handled the finances, that you weren't involved, that you told me not to ask about money. I closed my eyes. Have you signed it? No, but she says, if I don't, this will drag on. She says you're trying to put her in jail. I inhaled slowly. You don't have to choose sides. I said, you just tell the truth as you know it. But what if the truth hurts, Mom? There is no clean answer to that question. 2 days later, I received notice from the court. Lydia had filed for a temporary restraining order. She accused me of psychological intimidation, ongoing financial monitoring, and unauthorized access to personal email accounts. I read the allegations twice to make sure I understood them correctly. Unauthorized access. Email. I had never logged into Lydia's email. I didn't need to, but the filing alone was enough to destabilize anyone unfamiliar with the system. If granted, the order would prevent direct contact and complicate the legal process, making me appear retaliatory or unstable. Dana reacted immediately. This is tactical, she said. If they frame you as retaliating, everything you present becomes suspect in motive. The hearing on the restraining order was brief. The judge denied it due to lack of evidence, but the fact that it had been filed was enough to plant doubt. That same week, HR sent another email. Given the additional allegations regarding potential unauthorized data access, we require clarification before reinstatement. I was formally removed from Project Northbridge. My name was erased from the internal case management system. No one called it discipline, but I understood institutional language. That evening, Lydia stood in the living room, sharper than before. You think you've won? She asked. I don't think this is a competition, I replied. She gave a quiet laugh. You turned it into an investigation. Don't be surprised if people start investigating you. That was the first time I recognized the real risk. If anyone believed, even suspected, that I had accessed data improperly, my career could end. Lydia didn't need to prove I had committed a crime. She only needed to make me appear retaliatory. In family disputes, motive is often examined before evidence. For the first time since this began, I saw a scenario in which I could lose. Not because I was wrong, but because I was framed correctly. Dana did not respond to the restraining order with outrage. She responded with process. We don't defend, she said. We expand. That same afternoon, Dana filed a formal notice with Adult Protective Services. Not an accusation, not a complaint, simply a request for an independent review of how the power of attorney had been executed during a period of documented vulnerability. APS did not move loudly. They opened a file. Then they called the bank. When the bank heard the phrase vulnerable adult review, it did exactly what the system was designed to do. It expanded scope. Not 10 months, 2 years. Not just June's accounts. Any account Lydia had ever been authorized to access. I didn't ask for that. I didn't need to. Once a system begins moving on its own, it no longer depends on one person's voice. A compliance officer from the bank emailed Dana. We have identified transaction clusters requiring clarification. Additional documentation has been requested from the authorized party. Authorized party. Lydia. She called me that night. You triggered them, she said. Her voice was no longer composed. I responded to your petition. I replied, you're trying to make me look like a criminal. I'm letting the data speak. She was silent for a few seconds. Then she hung up. While APS and the bank widened their review, Dana did something more important. She required that all communication flow through her, not through me. The less visible you are, the harder it is to frame you as retaliating. She said. I agreed. I continued living in the same house as Lydia, but like parallel entities. She spoke to the kids. She emailed her attorney. She answered the compliance officer. I observed, and I withheld one thing. In the folder labeled Sequence on my laptop, there was a document Dana had not yet seen. Not the POA. Not the statements. A PDF I had reviewed multiple times. An invoice from Pierce Administrative Services, but not the version already disclosed. The original version. I found it in my mother's old email cache, an unsent draft that had been replaced by another version hours later. The first version's timestamp reflected a different internal IP address than the one Lydia typically used. Not enough to accuse, but enough to question. I didn't show it to Dana. Not yet, because if I introduced it too early, Lydia could build a counter-narrative before the system had time to verify. My silence wasn't fear. It was calibration. 2 days later, Dana called again. APS has requested a private interview with Lydia. She said, they've also asked for original copies of the invoices. Which version will she provide? I asked. Dana paused. We'll find out. That evening, Ryan texted me. Mom says they're twisting everything. She says you're enjoying this. I stared at the message longer than necessary. I didn't respond immediately. Instead, I reopened the sequence folder. There was one document, just one. If introduced at the right moment, it could change how the entire structure was perceived. I closed the laptop. In major investigations, the turning point isn't when you discover evidence, it's when the system is ready to hear it. And there was one document, just one that I had chosen not to introduce yet. Not the right time, but it was waiting. The hearing resumed after recess. The atmosphere had shifted. Not louder, just heavier. Dana stood. Your Honor, she said evenly, we would like to introduce Exhibit 17. Trent looked up sharply. Judge Sykes adjusted her glasses. Proceed. Dana did not look at me as she continued. Exhibit 17 is an earlier version of an invoice submitted by Pierce Administrative Services. A faint crease appeared between Lydia's brows. The document appeared on the screen. At first glance, it looked identical to the version already discussed. Same logo, same amount, same vague service description. Dana clicked again. Your Honor, we have examined the embedded metadata. Trent rose immediately. Objection. Foundation. Dana nodded calmly. Foundation has been established through digital forensic certification submitted in pre-hearing documentation. Judge Sykes reviewed the file briefly, then looked up. Overruled. Dana continued. This version of the invoice was created 11 days after the corresponding financial transfer occurred. There was no immediate reaction in the courtroom. So she clarified. The funds left June Caldwell's account on March 3rd. This invoice was generated on March 14th. She did not say fabricated. She didn't need to. Judge Sykes studied the screen longer than before. Trent countered quickly. An invoice generated after payment does not constitute fraud. Administrative lag is common. Dana did not argue. Agreed, she said. which is why Exhibit 17 contains an additional detail. She enlarged a portion of the metadata. An internal IP address appeared. Your Honor, this invoice was first drafted from a device not previously associated with Pierce Administrative Services. Speculation. Trent objected again. We are not speculating. Dana replied evenly. We are presenting origin data. Judge Sykes did not respond immediately. Instead, she turned toward Lydia. Mrs. Hartwell, were you aware that invoices were being generated after transfers? Lydia glanced at her attorney before answering. I trusted the administrative process. The answer wasn't false, but it wasn't complete. Dana continued. Your Honor, we have one additional witness. The courtroom door opened quietly. A woman in her late 40s entered, wearing a simple gray suit. No theatrics. No performance. Dana introduced her. Ms. Elaine Morris, Senior Compliance Officer at First Midwestern Bank. The room grew still. Elaine was sworn in. Dana kept her questions concise. Ms. Rishin, Morris, did you have contact with Mrs. Hartwell prior to June Caldwell's passing? Yes. In what context? Account clarification and contact authorization. Dana paused briefly. Did Mrs. Hartwell request a change to the primary contact designation on June Caldwell's account? Elaine reviewed a document. Yes. Trent stood. Relevance? Dana didn't raise her voice. The petition before this court asserts Mr. Coder. Caldwell lacks capacity to recognize exploitation. This testimony addresses whether he was intentionally excluded from recognition. Judge Sykes looked directly at the witness. Proceed. Elaine continued. Mrs. Hartwell requested that Mr. Caldwell be removed as a primary point of contact and that all financial communication be routed exclusively through her. No one shuffled papers now. Dana asked one final question. Did she provide a reason? Elaine answered without hesitation. She stated her husband doesn't understand financial documentation. The sentence settled into the room like a replayed recording. Judge Sykes straightened in her chair. Her expression was no longer curious. It was focused. Dana stepped forward. Your Honor, the petition frames Mrs. Hartwell as protective, but the evidence reflects sequential control, removal of access, consolidation of communication, post-transaction invoice generation, and finally a petition asserting incapacity. She paused. This was not protection. She did not finish the thought. Judge Sykes did. This appears to be preclusion, not protection. Exclusion. Lydia rose abruptly. That's not true. I was managing chaos. He doesn't engage. He doesn't understand context. Judge Sykes raised her hand. Sit down. Her voice was not loud, but it was final. Mrs. Hartwell, your petition asserts incapacity, yet the record now reflects deliberate exclusion of Mr. Caldwell from financial access prior to the alleged incapacity. Trent attempted to interject. Your Honor, the existence of marital division of labor. Division of labor. The judge interrupted. Does not justify removal of oversight followed by accusations of incompetence. The courtroom fell into complete silence. This was no longer argument. It was recognition. I did not speak. I didn't need to. Exhibit 17 remained on the screen. The compliance officer's testimony stood independently of me. Judge Sykes looked down at the file one last time. Based on the evidence presented, she said carefully, this court finds insufficient grounds to support the petition for conservatorship. She paused. And further, the court refers this matter for independent review regarding potential financial exploitation. The gavel struck, not loudly, but decisively. Lydia did not look at me as she left the courtroom. She stared straight ahead, as if still calculating. But for the first time since this began, the system was no longer moving along the narrative she had constructed. It was moving on data. Outside the courtroom, Dana walked beside me. She didn't smile. Timing, she said quietly. That was the only way. I nodded. There had been one document I chose not to introduce too early. not for shock, but for readiness. When it appeared, it didn't need to be loud. It only needed to be precise, and precise enough to change how the entire story was understood. When Judge Sykes's gavel came down, nothing ended. It began. The petition was denied. But the more important sentence had been her last one. This matter is referred to the district attorney for independent review. Referral. Not an immediate charge. Not a conviction. Just a transfer. But in the legal system, a referral is a door opening into a space where the story no longer belongs to two spouses arguing in a courtroom. Within 3 weeks, the district attorney's office issued formal notice. Janelle Pierce was subpoenaed. There were no flashing lights. No handcuffs. Just a demand for documentation and an order to appear for questioning. Pierce Administrative Services was not a large firm. No visible office. No registered staff. Just an entity on paper. When the subpoenaed records were submitted, the system did what it is designed to do. It compared. It cross-referenced. It mapped intersections between transfers, invoices, IP addresses, documented vulnerability, and the change in contact authorization. It did not need motive. It needed sequence. And the sequence began to speak. 6 weeks later, Lydia was formally charged. Not with the maximum counts available under the statute, but with enough to anchor a real case. Financial exploitation of a vulnerable adult, fraudulent documentation, improper fiduciary conduct. Trent Walden withdrew from representation shortly after the indictment. A new attorney stepped in. Negotiations took place behind closed doors. No press, no spectators. A plea offer was extended. Rejected. Another offer. Rejected. Lydia maintained the same narrative. She had managed chaos. She had protected the family. She had carried the burden because her husband did not engage. But the system does not evaluate emotion. It evaluates sequence, and the sequence had not changed. Invoices generated after transfers. Access removed before the petition. Power of attorney signed during documented confusion. 3 layers. Enough to support prosecution. Eventually, a plea was accepted. Class 2 felony. Not immediate prison, but a suspended sentence under strict conditions. 3 years suspended incarceration contingent on probation compliance. 5 years supervised probation. Full restitution with interest. Permanent prohibition from serving as a fiduciary or managing another person's financial assets. To satisfy restitution, Lydia was required to liquidate assets. One of them was a second property she had purchased the previous year under a separate trust. I learned about it from Dana's email. I was invited to attend the plea hearing. I declined. Dana attended on my behalf. She called when it was finished. "It's done," she said. I was sitting at the kitchen table when the phone rang. The same table where Lydia once called me useless. Dana summarized the terms. Her voice was neutral. Not triumphant. Not bitter. Just factual. When she finished, I didn't speak for a few seconds. "Are you there?" she asked. "I'm here," I said, and I realized I did not feel victorious. There was no surge of relief. No moment of vindication. Just a shift in weight. As if something heavy had finally been placed where it belonged. Ryan did not call on the day of the plea. Hannah sent a brief message. "Is it over?" I responded. "It's closed legally, not emotionally." She did not reply. That evening, I opened my mother's journal. I reread the final line. "If you're reading this, it means you didn't look away." I closed the book. The system had done its work. Not because I shouted, not because I won, but because data had finally been examined without distortion. I did not celebrate. I did not call anyone. I sat quietly. For the first time in months, the silence in the house no longer felt accusatory. It was simply silence. And sometimes, as I had learned, silence at the right moment carries more weight than any declaration. When the case closed on paper, life did not return to its previous position. It restructured, slowly. There are aftershocks that never appear in a verdict. They show up in missed calls, In pauses that stretched too long between two questions, Ryan did not visit for nearly 2 months after the plea. Then one Saturday evening, he called, "Dad, I found something." His voice was no longer defensive, just tired. He came over carrying an old envelope he had found in one of his mother's storage boxes. It was a bank notice addressed to June, dated 2 years before she passed. In blue ink at the bottom were the words, "Forwarded to L." It was not June's handwriting. Ryan looked at me as he set it on the table. "She never told me about this," he said. I nodded. "I know." He hesitated. "Why didn't you fight harder earlier?" I looked at the envelope. "Because when you fight with emotion, people choose sides. When you wait for the truth, they choose for themselves." Ryan didn't answer. But for the first time since this began, his eyes no longer wavered. That was enough. Hannah chose a different path. She began therapy. Not because the court required it, because she realized loyalty can blur judgment. One afternoon, she asked me, "Is it wrong that I still love her?" "No," I said immediately. She waited. "But loving someone doesn't mean defending every decision they make." She nodded. That was the hardest lesson for her. That love and truth can exist at the same time, but they are not substitutes for each other. Lydia never apologized. She completed her probation requirements. She filed her financial disclosures. She paid restitution on schedule. But no letter ever arrived containing the words, "I was wrong." Only statements shaped like self-defense. I stopped expecting anything else. Some people understand consequences. They never understand responsibility. Restitution was completed in late spring. A letter from the court clerk confirmed that the full amount, including interest, had been repaid. June's estate was officially closed. When I read the final line, I did not feel satisfaction. Only closure. A chapter, not a life. I sold the Oak Park house in early autumn. On the day I handed over the keys, I walked through each room one last time. The living room where June read in the afternoons, the kitchen where she balanced her checkbook every Sunday. 2 teaspoons of sugar, a little milk, a small notebook beside her. I placed her journal on the kitchen counter, not to leave it, just to acknowledge it. I didn't look away, I said quietly. Then I picked it up and closed the door. Work resumed at its old rhythm. With additional conditions, periodic oversight, I did not object. Trust does not rebuild in a single meeting. It accumulates, like everything else. One morning I woke before 6. The house was still. No anticipation of a phone ringing. No emails beginning with "given the allegations." Just pale light filtering through the curtains. I made coffee. 2 teaspoons of sugar, a little milk. Like my mother, I sat at the kitchen table without documents, without timelines, without Exhibit 17. Just the quiet I once mistook for emptiness. I thought about the word useless, how easily it had been spoken, how confidently it had been believed, and how quickly it collapsed when confronted with sequence. Silence doesn't mean ignorance. Calm doesn't mean weakness. And being underestimated is only dangerous if you believe it too. Lydia thought I was invisible. She thought I wasn't paying attention. She thought paper could be rearranged without consequence. But my mother taught me something different. Paper does not forget. Paper remembers. And sometimes justice does not require applause. It only requires patience and the willingness to let the truth be read correctly